Yes. तो इसलिए we are always eager to hear you.
अरे सर, my pleasure sir. I am honored sir, मदन सर.
हाँ गया
आ गई लाइट कमल जी?
कमल जी अनम्यूट.
वैसे लाइट तो नहीं आई है, बस 7 बज गया है, तो मैं सेशन स्टार्ट करते हैं सर. सर मैं सीए डॉक्टर राकेश गुप्ता जी का जबलपुर संस्कार धानी में वर्चुअल माध्यम से बहुत बहुत स्वागत करता हूं सर. और सर मैं वैसे तो हम आपको रूबरू सुनना चाहते थे, पर अभी जो जिस तारीख में हमारा सेमिनार है उस दिन आप वर्किंग डे था, तो आपने बोला कि वर्किंग डे पे तो नहीं आ पाएंगे, तो फिर फ्यूचर में हम आपको किसी कॉन्फ्रेंस के लिए जरूर इनवाइट करेंगे सर. तो मैं चाहता हूँ सर आज के सेशन आप स्टार्ट करें सर. और सर आप कोस्ट तो आप म्यूट कर सकते हैं किसी को यदि कुछ ऐसे दिख रहा है, क्योंकि मेरा लाइट नहीं तो मैं नहीं कर पा रहा हूँ.
Should I begin?
यस यस
Yes sir.
Okay. लेकिन मैं रिक्वेस्ट करूंगा सभी लोगों को म्यूट कर लें अपने आप ना, बीच में डिस्टरबेंस आ रही है.
नहीं नहीं कुछ नहीं गिराया, नहीं गिराया, मम्मी ने गिराया.
अनुज जैन साहब इसको बंद कर लीजिए प्लीज. ओके फ्रेंड्स, this is the beauty of Zoom, that not very long ago I was connected with Calcutta and now I am connected with all of you. Thank you for inviting me to be with all of you this evening to deal with practical and legal issues in first appeal. Income Tax Act is not an exception. And like any other enactment, it provides for the redressal of the grievance by filing appeal. But at the same time, in the same breath, we must not lose to a basic fact that this right of appeal is a statute given right. Nobody should be taking as if this is an inherent right. This right is there so long as the statute so provides for it. And that is why whenever we happen to receive an order, we scan section 246 capital A of the Income Tax Act to see whether this order is appealable or not. Because not all orders are appealable. And therefore, this has to be borne in our mind. I remember today when I was connected with Calcutta, somebody was saying, sir, an order under section 148 AD has been passed. Now, can I file appeal against that? No. Because that is an interlocutory order number 1. And no appeal has been prescribed against this order. सर आप अपना बंद कर लेंगे सर? हाँ. सर टेलीफोन कर रहे हैं आप, मुझे नाम तो नहीं मालूम आपका. धीरज गई साहब प्लीज.
सर मैंने बंद कर दिया.
So nice of you. So nice of you. So therefore, but then the question comes, and somebody can ask that can our system be so cruel that if an adverse order has been passed and yet no appeal has been prescribed, as if a person has been or person is sought to be left in the lurch? No, it's not like this. When an order is not appealable, then there is a constitutional remedy by way of a writ before the concerned High Court. You must have seen, you apply for the lower deduction of tax at source certificate from the assessing officer. He does not issue you the certificate or issue you the certificate with which you are not satisfied. You wanted a nil deduction of tax, but then he has issued, say, 1% deduction of tax. So you may not be satisfied, but then this kind of an order, even if it is an adverse order, now cannot be appealed against. Similarly, if your return has been found to be defective, an order is passed under subsection 9 of section 139 of the Income Tax Act, then you don't have any right to appeal against such kind of an order. Though this order is highly an adverse order, it is an adversarial order, and yet the legislature has not envisaged for you to give any right or confer any right to file appeal. Therefore, at the very first thing which must come in our mind, whenever our client comes crying, sir, this adverse order has been passed. Sir, I applied for the stay of demand and it has been rejected. Now, this is one of the harshest orders under the Income Tax Act, but then there is no appeal prescribed against such a rejection. Therefore, this is a statute given right, and therefore, this right to file appeal against an order is there so long as the statute recognizes this right. Now, practically, what happens? The return is processed under section 143(1). And I tell you, I have seen a good number of cases. The processing takes place. Some adjustments are made in that processing by the CPC. Demands are raised, I mean, for some reasons or for not so explicable reasons. But then we do not resort to any kind of remedial measure against such kind of demand, ostensibly under this belief and faith that when our assessment will ultimately be done under section 143(3), then we can agitate, I mean, this kind of demand which has been raised in the processing. But then that is not the correct thinking in law, because if adjustment has been made under section 143(1) intimation, if demand has been raised in the intimation under section 143(1), then your cause of action lies against that intimation. Therefore, the appeal must be filed against that intimation. So this is one thing which I find my professional friends do at times falter. Then the second thing which I have seen, and which I would like to discuss and dwell in this webinar, is that many times, even against such kind of adjustments which are done by CPC under section 143(1), we, instead of filing appeal, we explore the possibility of moving 154 petitions. Of course, 154 remedy is available, but then we should not rest at that remedy alone, because that remedy may not be a final remedy. It may not bring any relief to you, maybe for the reason that the assessing office of the CPC, for that matter, chooses to sit over your application under section 154, and therefore you may not get any reprieve or relief because of the non-disposition or non-disposal of a 154 petition. Therefore, I would always suggest that you have got very potent weapon in your hand, that is by way of filing appeal. Therefore, you must file appeal against intimation under section 143(1), which is adverse to you, and then you can explore the possibility of moving 154. And in case your 154 petition is allowed, then you can always withdraw the appeal before the CIT appeal. But then if you keep on banking upon only on petition under section 154 and appeal being a limitation matter, the time limit for filing appeal may well expire, and then you may find yourself in a very difficult situation. So instead of banking upon or solely relying upon your rectifications power or rectifications right, you must invariably file appeal, that too within time, before the appellate authority. This is very unfair. Himanshu ji, if you are not, please mute yourself, Himanshu ji. It obstructs. I have been told by Kamalji that, I mean, only those who are very keen to listen and Kamalji, kindly see, Madan Sahab, kindly see. It will be difficult for me to continue to speak like this.
Wait, sir.
Not everybody is muted. Yeah, children's voice.
Yes, sir. Now it is. Sorry, sir. We are very sorry. After me.
Sir, not getting your voice.
Sir, I mean, Kamalji probably muted me also.
Yes, sir. Yes.
Sir, the next thing, very important thing which I was telling and which I have seen practically in my professional life, that at times we ignore this important fact before filing appeal to see that tax on the return income must stand paid, because there is section 249 subsection 4. It has got two subclauses, small a and small b. And small a says that where the return has been filed, then the tax on the return income must stand paid. And in case that tax is not paid, then your appeal is not maintainable. The day when you happen to recoup that kind of a deficit, you will be deemed to have filed appeal on that date. Then in that situation, your appeal will be treated to have been filed belatedly, and then you would be required to move a condonation petition. And even clause B, where the return has not been filed, then you are required to pay that much amount of tax which you were required under the law to pay by way of advance tax. So that is because under the Income Tax Act, the advance tax is required to be computed by you under section 209. There are several A, B, C, D of section 209, subsection 1, clause A, B, C, D. So you'll have to compute your advance tax liability, and then before you file appeal, you must ensure that the amount of advance tax, in case the return has not been filed, which you ought to have paid by way of advance tax in that situation, that must be paid. Otherwise, your appeal will not be maintainable. Commissioner Appeal will issue a notice as to why your appeal should not be held non-maintainable, and then after soliciting and eliciting your reply, then he may decide or dispose it of, maybe against you. So this is very important thing. Then the next important thing, practical thing, and of course, I mean, whatever I'm discussing, I mean the hardcore practical things. And then next thing which I have seen many times in case of the corporate SSEs or in case of the statutory corporations, the competent authority envisaged under the Act who is required to sign appeal now doesn't sign. In case of a company SSE, I can say that if there is a managing director, yet I have seen good number of cases that the managing directors do not sign appeals and the directors sign. So that is very risky propositions. You must ensure that your appeals are filed under the signatures of the competent authority. Similarly, in case of the statutory corporations, there must be some authority who is given power of attorney or authority by the statutory corporations. So that authority, I mean, must sign, and not anybody. I have seen in many statutory corporations now CFO or the director of finance, without there being any specific authority to sign, I mean, they just sign the appeal, and that creates a problem. Then one more important legal aspect, and of course practical one, is that when a consolidated order is passed under different sections, say there is a penalty for non-filing of a particular, like TDS, there are several obligations under the TDS provisions, and which entail separate consequences. But then the assessing officers or the authority which imposes that tax liability or pecuniary burden, it passes a consolidated order mentioning different sections. Now, in that situation, it would be better in case you happen to file appeal against such orders separately. And if you file a consolidated one appeal, whereas the defaults were separate and distinct, and you ought to have filed separate and distinct appeal, then that's in that situation, by filing consolidated appeal, you may create a problem. I'm not saying that these problems cannot be resolved or commissioners can decide it in mechanical manner. It's not like this. But then I always say that let us conserve our energy to contest a case on the merit of the additions instead of frittering away or wasting our energy on such kind of hyper-technical and technical issues which would come in your way. Now appeal has been filed. I'm not going on that it should be filed in time and it should be filed, but then I'm not going on that aspect. You all are aware. But then I'm coming much more important. I have seen there is a column now under Form 35 that you'll have to file. Earlier also it used to be there, statement of facts. And therefore, statement of facts is required because it is prescribed under the rules, therefore it's required to be filed. But at this stage, to what extent you must give the statement of facts, that may be a question. And that question is dependent upon your workload. That question is dependent upon to what extent you have gone through the client's file so comprehensively. Because at this stage, whatever facts you would mention, you would be bound to some extent by the statement of facts which you file at this stage. There may well be the possibility that because of the paucity of time, because appeal has to be filed within 30 days, you may be having several clients. You have to file tens and hundreds of appeals. So maybe within that short span, and many of the clients may have walked in to you, they may not be the clients with whom or for whom you have done assessment. So within that 30 days, when the work pressure is too much, there may not well be the adequate time at your disposal in which you really devote time to grasp the facts which must be mentioned in the statement of facts, and therefore any incorrect fact or incomplete fact or a fact which ought to be mentioned somehow is skipped by you. Now all these things may create problem at later stage. So at this stage, the bare minimum facts may be given, and of course the right, is there under the law that whenever you will file your written submissions, you can, by that time you must have gone through the brief of the client very comprehensively, very coolly, calmly, patiently, and then a statement of fact. At that stage, you will incorporate them in your written submissions. So it's better that you make a statement of facts at this stage while filing appeal, may not be in a very comprehensive manner, only a crisp, concise manner. So that the statutory compliance of furnishing the statement of facts is met. That's all. Then the grounds of appeal. Now, grounds of appeal are very important, and I have seen many times our professional friends do not give that much attention to this aspect of the appeal, which is very central, which is very vital. Now, grounds of appeal as per the law of pleading must not be argumentative. They have to be concise. When I say concise, that they should be shorn of any logic, reason behind it. Because the moment you incorporate the reason, then that ground of appeal becomes argumentative. And the law of pleading says that grounds of appeal should not be argumentative. In fact, appellate tribunal rules, though first appeal is governed by the normal law of pleading in this regard, but appellate tribunal rules which governs the filing of appeal before the income tax appellate tribunal, there is a specific rule under the appellate tribunal rules which says clearly that the grounds of appeal should be concise and should not be argumentative. And that is why my friends, those who appear in the income tax appellate tribunal, may have faced this kind of situations. The bench says your grounds are argumentative, and therefore you kindly alter them or concise them as per the appellate tribunal rules. But be that as it may, the law of pleading says that the grounds of appeal should be concise. Your grievance must come. So if an addition has been made, your ground of appeal can be as concise as this that the assessing officer has added in making addition of this under section 68. Assessing officer has added in making additions of this much as undisclosed investment under section 69 or 69A. So your grounds must bring your grievance. Many times I have seen my chartered accountant friends and my, of course, lawyers and those who practice on this side, they incorporate or pour in their sentiments and emotions in the grounds of appeal, and which I say very jokingly and in a very light-hearted manner that grounds of appeal is not a place to express your sentiments. There are better places to express so they have to be concise, but at the same time your grievance must come. Your grounds of appeal now must be drafted. These are suggestive, of course. There are no codified rules except that law of pleading, general law of pleading, that they need not be argumentative and they have to be concise. But then these are suggestive from my side that the very first ground, I always say, and today also I'll say, I'm speaking after a long time, at least before your branch, Jabalpur branch, and very recently, about 3-4 days back, your own Narendra Kumar Belaiya Sahab, who is posted as accountant member here, he is from Jabalpur. He said to me, why don't you go to Jabalpur to give lecture? I said, sir, I am going. Bole, who called you? I was missing the name. Then Kamal must have called you. Yes, Kamal just called me. So anyway, so since I'm speaking after a long time, therefore, I don't have any hesitations giving some suggestive tips, though my contemporaries, my elders are there. I'm watching some of them on the screen. But then there are juniors also. So maybe it may be to their advantage. The first of all, your ground must deny your accessibility. So your ground must be the first ground, which I always say should be like a hathi ka pav, which covers your entire gamut of your grievances, so that if at any stage you are found wanting by not taking a particular ground, you can always cover, you can always fall back on this ground, which is the umbrella ground, is that the appellant denies its liability to be assessed at such and such income and denies its liability to pay tax and interest demanded thereon. So your very act of deniability to be assessed. Now you kindly see how many facets you have denied. First of all, you have denied your assessment at a particular figure, meaning thereby that all additions and disalliances, which when aggregated, and that aggregation will become the ultimate amount of your assessed income, you are denying. Meaning thereby that by denying the very assessment at a particular figure, you are denying the separate additions also. But then I'm not saying that you take only this ground. This must be the first umbrella ground. So first, when you deny the very assessment at a particular figure, you are denying the assessment. Then you are denying your assessment in a particular status automatically. When you are denying to pay tax and interest, you are denying your liability to be assessed for this year. So when you deny your very liability to be assessed at a particular figure, and when you deny your liability to pay tax and interest, then the entire gamut which affect your substantive rights, now they are subsumed by this umbrella ground. Therefore, your first ground must be your denial. Then your denial, kindly see, you are denying your liability to be assessed under a particular section. So this kind of umbrella ground must be taken. This is suggestive. My humble suggestion may not be accepted. Then I have seen many times that my friends, they do not challenge the jurisdiction. I'm not saying the territorial jurisdiction as of now, but legal jurisdiction. When the assessing officer assumes a jurisdiction to make assessment by issuing a notice under section 143(2) or by issuing notice under section 148, now there is a legal jurisdiction which is assumed by him. Therefore, your ground must invariably be challenging that assumption of jurisdiction by the assessing officer. So when you say that the assessing officer has erred in assuming jurisdiction, then you are challenging assuming jurisdiction to make this assessment, assuming jurisdiction to reopen the assessment. So, and of course, territorial jurisdiction also. Though if you want to challenge the territorial jurisdiction, there is one more rider under section 124 that you have to challenge the territorial jurisdiction of an assessing officer within a particular time frame. And in case you do not challenge the territorial jurisdiction before the assessing officer within a particular time frame, which is there under section 124, then your very right to challenge territorial jurisdiction in appeal now is not there. But I'm assuming that 143(2) jurisdiction to pass this assessment order, jurisdiction assumed for reopening the assessment, jurisdiction assumed to pass this assessment order after you assumed jurisdiction to reopen the assessment, and all these kind of jurisdiction you challenge in an umbrella ground that the assessing officer has erred in assuming jurisdiction, whether to pass this assessment order, whether to reopen the concluded assessment. I mean, that you can argue in your the written submissions. The entire word is open for you. The next thing which I have seen, that at times the assessing officer makes certain references. He makes references to the district valuation officer. He makes references to the transfer pricing officer, or he can make reference for several other purposes. He may make reference to obtaining certain exchange information from the foreign countries under double taxation avoidance agreement. So assessing officer under the law is competent to make various references. He may make references under section 55A. He may make reference to he may make reference to district valuation under section 142A. So whenever all these things are done, then you challenge that the assessing officer has erred in making reference. You never know that is very act of making a reference to the valuation officer may be bad. I remember, I tell you, I must share that it was a case of determining the fair market value as on 1/4/1981. Now it is 2001. That time it used to be 1/4/1981 of a capital asset which was acquired by the SSE or the previous owner prior to that date. Now assessing officer made reference to the district valuation officer to determine its fair market value as on 1/4/1981. Now we challenged the reference, and very frankly I tell you, I am talking of, I mean, long back, we challenged the action of assessing officer in making reference to the valuation officer. At that point of time, not knowing for why I am challenging it. But then later on, when I read the law, I found that since it is a case where DVO was appointed to determine its fair market value, which could be lower than the value shown by me, and which was not permissible at that time under section 55A. He could have made reference under section 55A to determine the value as on 1/4/1981 prior to 1/7/2012, when he wanted its valuation to be higher than what you have shown, not the lower. So his very act of making reference to the DVO for determining value under section 55 capital A to determine value as on 1/4/1981, that was called in question by us by raising a general ground of making reference by assessing officer, and then it found favor, and the matter went up till the High Court, and High Court approved it based upon Puja Prints of Bombay High Court's decision. So whenever assessing officer makes a reference, challenge it. Then non-observance of principle of natural justice. Now this is such a ground that the assessing officer has erred in not observing the principle of natural justice. Now again, this is all embracing umbrella ground. Now in this, you can agitate that some material has been collected at your back. Some material collected at your back has not been confronted to you. Some witness has been called by the investigation wing or by the assessing officer at your back. His statement has not been supplied. He has not been allowed to be cross-examined. Order is non-speaking. Now, all these are facets of non-observance of the principles of natural justice. Therefore, you take this ground of non-observance of principle of natural justice. Then, of course, you will have to agitate all additions and the disalliances. All additions and the disalliances made by the assessing officer. Now, one thing which is very important and which I have seen many times, few of us may omit and forget and escape, that some claim was made by the SSE, whether in the return or during assessment. A fresh claim was made during assessment, or some claim was made in the return, now which has not been allowed by the assessing officer, which may have been denied by the assessing officer, not by making any discussion in the order. And at times, since the discussion has not been made, there may be possibility that omission on the part of the assessing officer may lead to our omission. Because whatever he discusses in the assessment order, naturally we will read the assessment order. Then when we will find the adverse finding in the assessment order, we will raise ground of appeal qua each adverse finding of the assessing officer. But if some claim made by you, some deduction claimed by you in the return of income, now he does not deal, he does not discuss, he does not disallow, explicitly or by making any categorical discussion in the order. So there is a possibility that it may go unnoticed even at your end. And that is why I always say that prepare a reconciliation between the computation of income and the computation made by the assessing officer in the assessment order, because that reconciliation between the computation of income and the computation made by the assessing officer in the assessment order, that will bring as to which kind of variances are there between the two. Then there may be some claim which may have been made by you during the course of assessment, not by way of return or not by way of a revised return. Now, Supreme Court says in Goetz that in case a claim has not been made in the return or in the revised return, then assessing officer cannot admit that claim. But Supreme Court has said in that very decision in the same breath that there may be fetters, restrictions on the power of the assessing officer, but there are no such powers on the powers of the first appellate authority, or for that matter, any appellate authority. So, if there is some claim made by you in the assessment proceeding through your letter, not by way of filing revised return, then also you must be aware that you have to raise a ground of appeal qua that kind of claim, which may have been totally ignored by the assessing officer in his assessment order, that by saying that the assessing officer has erred in not considering and not allowing this claim. So I am discussing only those facets where we may skip, we may omit, we may leave, and therefore, and in the last, you may take a general ground that the appellant craves the leave to add, amend, delete any ground or grounds of appeal before at the time of hearing. So that kind of a ground or a right reserved by you, I mean, then you can raise alternative grounds also in the grounds of appeal. Or if this, like for example, suppose if I have paid, if department says that you have paid on money on the purchase of land. So alternative claim, your claim may be that that particular addition which has been made in this year or in earlier years in respect of some on money which I have received, now that has been used at best against this kind of addition which you make, then that alternative ground you can raise it, or you can raise it through your written submissions also. That is permissible. Yes. Then now your certain rights of additional evidence I'll speak. In fact, the appellate authorities are debarred as a blanket proposition, first of all, by Rule 46A, that they would not admit any documentary or oral evidence which were not before the authority below, except in 4 situations where assessing officer passed the assessment order or a particular addition without giving you the opportunity of hearing, whether and where you were prevented by sufficient cause when assessing officer called upon you to justify a particular claim, or when you were prevented by sufficient cause in otherwise. So 4 situations, clause A, B, C, D under Rule 46A has been envisaged by the legislature, which permits the appellate authorities to consider your claim of additional evidence. But then if you ask me, my guru told me, I remember on the very first day when I became chartered accountant and I went to him, he told me that your success would depend, and I tell you that is the biggest asset with me even today. Your success would depend on this, your visualization skill, that you imagine, you visualize, you envisage, you contemplate, you think that what kind of facts and evidences should be placed by you, and evidences should be placed by you and thereby you may not be required to file or move any additional evidence. Because when there is a blanket ban on the appellate authority to admit additional evidences which have not been filed, or to admit such kind of additional evidence only in specified circumstances, so your energy will be frittered away in getting that evidence admitted, and that energy which you could have used in order to contest a particular claim on merit before the appellate authority, that should be conserved. Therefore, he said, I do still remember, he said that, imagine, that he said, I remember, that if you lead yourself in a situation whereby you are forced to move additional evidence, then you take it as if half of the battle is lost. And since then, I tell you, my mind works at the time of assessment as to what kind of pleadings on facts I would require, what kind of evidences on facts I would require. I ensure that I place it before the assessing officer before the conclusion of that proceeding, so that this evidence which I have already filed does not become and is not called technically as additional evidence. Therefore, I need not to undergo that kind of arduous process, torturous and treacherous process of getting it admitted as additional evidence. So if you, but then I am not saying that additional evidences would not be required. At times it may be required. Suppose, as situation envisaged in the rule 46A is that where the assessing officer did not give you opportunity. So in that situation, what would you do? You will be forced to move additional evidence. But whenever you file additional evidence, you must ensure that you prepare a petition detailing out as to what prevented you from filing and submitting that additional evidence, and then bring it on record. Because the first appellate authority will have to record, first of all, that this opportunity will have to be provided to the opposite party, that is the assessing officer. Then after soliciting his objections, then appellate authority will have to take a judicious decision now whether this evidences should be admitted or not. So drafting of petition, because additional evidence may be very crucial evidence, since you are filing it as additional evidence. So I have got every reason to believe that evidence must be very crucial and important for establishing your claim. And in case the first appellate authority does not admit your additional evidence, it may prejudice your case, and therefore you may feel aggrieved against such kind of an adverse order. And then you may like to challenge the action of the first appellate authority not admitting the additional evidence before the tribunal. Similarly, additional ground. Attempt should be made that there should not be any occasion for you to file additional ground. But then your additional ground petition must make out a case as to what prevented you from filing, that ground. But Supreme Court has said that the legal grounds which go to the root of the matter, which do not require fresh facts to be investigated, should be admitted. But then grounds on facts, you'll have to make out a petitions very effectively as to what has prevented you from not incorporating this ground of appeal in your original appeal memo. And there is limitation on the power of the first appellate authority because it has been provided under subsection 5 of section 250 that the first appellate authority will see that your prayer is that this omission is not willful. Kindly see that first appellate authority will see whether this omission of non-inclusion of this ground in your original appeal memo was not willful. And there is one more. So you make out the petition as to what prevented you from filing this additional ground petition, because again the first appellate authority is required to confront this petition to the assessing officer, invite his objections, and then take a judicious call whether to admit this additional ground or not. Then written submissions will have to be prepared by you, making out the facts, the admitted facts, the facts to be proved, and then I'll not speak.
Sorry, sir, for this inconvenience. I'm very sorry, sir.
Kamalji, I hope you have muted everybody, na?
Had he done so, then it could not have come from the heaven.
Kamalji. Till that sound is coming. Kamal.
Okay. Yes. So the written submissions, paper book, kindly ensure that paper book contains only those evidences and pleadings which have been made before the assessing officer before the conclusion of assessment process. If there is any additional evidence, then that must be enclosed along with your petition of additional evidences. That should preferably be not made part of the paper book. Now, first appellate authority, though, has not been envisaged under the Act that it has got any power to grant you stay against the demand or not, but then Supreme Court had settled this position in Muhammad Kuni's case that there are certain powers which are inherent in any appellate authority and which can be taken to exist in order to dispose the appeal effectively and efficaciously. So power to grant stay is taken as subservient power of the appellate authority. It's a necessary adjunct and necessary power of the appellate authority. Therefore, you must file stay petitions before the first appellate authority by taking help of the Supreme Court's decision in Muhammad Kuni's case. And now there are plethoras of judicial decisions after Muhammad Kuni's case, because Muhammad Kuni's case in 71 ITR at page 315, but thereafter lots of high courts have taken the same view. You must file a petition seeking stay of demand from the first appellate authority, apart from you moving stay petitions before the assessing officer. Because whenever the department would like to attach your bank account, you can always demonstrate that a grave injustice is being done by the department because your stay petition is pending before the first appellate authority. In your stay petition also, you must establish a strong prima facie case. You must establish the financial strain. And not only should you say, but then you must substantiate also. I always say that all petitions which you make, that petition may be even the adjournment petition before the commissioner appeal. Even if you move petition for additional ground, you move petition for additional evidence, you move petition for stay, or for that matter, any petition which you choose or seek or think to move before the appellate authority, I always say you take the bottom line when you prepare that petition, that if tomorrow it is rejected by the commissioner appeal, then against that rejection, if you knock at the door of the High Court, now that petition must be prepared in that manner that by taking the entire gamut of your facts and contentions raised in that petition, you can always knock at the door of the High Court. I have seen my friends drafting petitions in a very laconic, casual, mechanical manner. It should never be done. Adjournment petition, no reason is advanced. Even if reason is advanced, it's not supported with evidence. And I have seen, because in the tribunal I appear daily, I see many times we chartered accountants prepare the petitions as mechanical manner. That very reason now is repeated, say for 6 months. So that shows that we are not sincere and serious in drafting petitions. Maybe we are not according the due weightage to the adjournment petitions by probably assuming that this is the most clerical thing. It's not like this. Suppose if tomorrow your adjournment petition and is not granted by the commissioner appeal, then you must be aggrieved. Then the tribunal would see, when you will file appeal against the order of the CIT appeal, the tribunal would see, okay, what was the reason? What reason was advanced by you? How did you support that reason? And though the tribunal, I would say, is quite generous and very, what should I say, very generous in remanding the matter back to the commissioner in case it finds that the commissioner has decided ex parte. But then we cannot take any appellate authority for granted. I mean, it depends upon bench to bench also. It depends upon, the recalcitrant behavior of a particular SSE over a number of times. So it depends upon so many factors that we should not. So any petition which you draft, that must be drafted in such a manner that in case it is not granted by the appellate authority, and tomorrow you may have to go to the higher next best level or forum, either of appeal or writ, then this very petition acts as the launching pad for you to attack against that non-granting. Now, CIT appeals has got power to enhance. That's very important power, because once you file an appeal, then you cannot withdraw that appeal unilaterally. You can withdraw it provided you seek the permission of the appellate authority, because once you have set the ball of appeal in motion, then it is not in your hand. That you have chosen to file appeal as per the statute given right. Now you want to withdraw it, you can withdraw it. No, it's not like this. You can withdraw it, of course, but then if the commissioner appeal chooses not to allow you to withdraw the appeal, then probably, you have got not very many options against that kind of a judicious decision taken by the commissioner appeal. Commissioner appeal has got very important power. That power is of enhancement. Therefore, now this kind of a decision must be taken at the time when you initiate the action of filing appeal. Now, can there be any possibility of enhancement by the commissioner appeal? Though it is very difficult to envisage all situations, because law has gone to this extent that the commissioner appeal has got all those powers which the assessing officer has got. His powers are coterminous with that of the powers of the assessing officer. He can do what the assessing officer could have done. He can do what assessing officers could have done, but then has not done. Therefore, the power of CIT appeal, and there is a purpose, there is a philosophy, there is a reason, there is a rationale for giving such kind of power to first appeal, because there is no appeal prescribed against the assessment order to be filed by the revenue. Yes, of course, principal commissioner can revise that order under section 263, but then there is no appeal prescribed against that assessment order to be preferred by revenue. That is why the first appellate authority has been given power of enhancement. According to me, and of course that my view is based upon the Supreme Court decisions of late. That kind of proposition has come to be diluted by several decisions of the tribunal. But I would say that CIT appeal has got very wide power of enhancement, and therefore, we have to keep that kind of power of enhancement in our mind. Then I think most of the issues I have touched upon, maybe very quickly. But then I must, and I have been told by Kamalji that I speak for 1 hour. I will not be doing my duty if I do not spare some time for some questions. There are 2 questions, probably it appears in chat box. Therefore, I think it will be better in case I take unable to hear. No, there are no questions in the chat box. So Kamalji, I think there are 10 minutes and we can take questions.
Yes, sir.
Yes. So there are
any query?
If there are no questions, then I'll speak further.
Yes, sir, you carry on, please.
Okay. Now, how to draft written submissions? Again, I would say with utmost humility, I would say it is only a suggestion based upon my experience of 38 years as a practicing chartered accountant, as a practicing lawyer, as an SSE, and as a judge. So now I have seen why I'm dealing this. I am dealing this because I have seen my many friends preparing written submissions in a very back and forth manner, in a very zigzag manner, not in a very structured manner. Sometimes they will say what assessing officer has said, then they will say at the same time what the SSE has said, then they will say at the same time that the assessing officer has not done this. So that does not make a very cohesive reading. So after seeing all these things and based on my experience 38, 39 years, now I would say suppose there is one ground and let us take the easiest ground, because this is only with a view to showcase my suggestion, like share capital, which has been added along with the premium. Now that is the point of dispute. Addition has been made and you are in appeal. And while preparing your written submissions, your one para should capture the dispute in such a manner that the reader of your written submissions, by reading that para, should understand as to what is the dispute and why is this dispute. And I would add and suggest, I would add rather, not suggest, that crispiness of this para would depend upon your, of course, experience. So you say the ground relates to the addition of this much on account of share capital treated by the assessing officer as unclaimed and unproved, because according to the assessing officer, the identity and capacity of the shareholders and the genuineness of the share capital have not been proved on the basis of certain allegations and inquiries conducted by the department. Now the reader, whether it's CIT appeal, whether you yourself are, anybody who would read your written submissions from the very reading of your very first para would capture as to, oh, this is the dispute, why the addition was made. It should come. After all, that reader would read the entire assessment order later on, read your entire submissions later on, but your first para must capture the dispute with the reasons in concise manner, not in a very comprehensive manner. Then now you'll have to prove all these things on the basis of which the addition has been made. So your next para must bring out the admitted facts, the facts which have been which are admitted by you, by your SSE, the facts which are admitted by the assessing officer, because in any dispute, it's not as if always there will be dispute right from the word go. Till some stage, there may be point of convergence. There, like in this example, the convergence is that I also say that this much is the amount of the share capital. I also admit that this is the amount of premium. Assessing officer also says these are the persons from whom I have raised the share capital. He also says that this is, so I need not to prove this, because this I say and the assessing officer also admits it in the assessment order. And these admitted facts are necessary for you to take your written submissions further. So your next para must capture the admitted facts, and those admitted facts which are admitted by you, which are admitted by the assessing officer in the assessment order, on which there is no dispute, and such facts are essential for you to proceed for establishing your further claim. The next para should ideally capture those facts which you want those facts to be proved which the department disputes. So you prove positively on the basis of your averments, on the basis of your pleadings, on the basis of you making submissions in the before the assessing officer, and then on the basis of the evidences which you have found. So, like in this case, sir, SSE has received earlier the admitted facts, then this share capital has been received from these persons through banking channel. Now, because these may be contentious issues, through banking channel, and we have filed confirmations, they are assessed to tax, and the premium has been worked out on some plausible basis. They have confirmed it, they are assessed to tax, they have filed their permanent account number, they have given their balance sheet, they have submitted their bank statement showing the source, and in turn these companies have received the amount from such and such, so the evidence of which is also there. Now you thereafter you list out all your pleadings with page number of the paper book and your evidences. So you are in this para are proving those things as facts on the basis of evidence which the assessing officer has disputed it. You are proving positively. What I have seen, you prove something, at the same time assessing officer has not done this, assessing officer has done this wrongly. No, you, because delineate your positive proving in this para. Don't indulge with assessing officer at this stage. You make out your case. Because if you prove your case, then you rebut and negate assessing officer at the same time, that back and forth will not make the reading of your written submissions in a very structured manner. So, first para, dispute capturing. Second para, what is admitted facts. Third para, those things which you want appellate authority to accept it as a fact based upon the evidences. Then, in the light of these facts, then what is the law? And what is the law? And what are the judicial decisions? Now, till this stage, you have proved your case positively. Now, last segment of your written submission should be that each and every adverse observation of the assessing officer is met as under. Now you pick up each and every adverse thing which has been said by assessing officer, capture it point wise, and then give reply. And while giving reply, also you may have to refer your paper book, which maybe you may have referred it a little while ago while establishing your case positively. Now, in this manner, when you prepare your written submission, it will come out in a very structured manner. It will come out in a very cohesive manner, in a very, very systematic manner, and that will make a sense, and that may hit the reason of the person. So friends, now it is 7. Thank you. Thank you from the core of my heart. Jabalpur, I want to come in person, but then this time, because Kamalji wanted to call me at very short notice, it may not be possible, because 5 days I have got, brisk court hearings. I can't come in those 5 days. I can come on Friday. Saturday, Sunday now has become a problem because my wife is sitting member of the Income Tax Appellate Tribunal. She comes on Friday, goes on Monday. So if I disappear in those 2 days, then, then it becomes difficult. So it has become difficult for me. But anyway, on Friday, I can make out. And since my wife is too accommodative, she says, no, whatever, wherever you feel good, you do it. So I can come on Friday, Saturday. But then I have found this mechanism of conveying is very useful, very time saving. Abhi that day on last Saturday only, I went to Guwahati. And I asked them, and that was on faceless. I started my deliberations. I mean, what kind of a faceless? By inviting me in a faceful manner, that too from 2000 kilometers away, and for giving lectures of 1.5 hours or 2 hours. And now you see the kind of pain. I went in the morning, came in the late evening. I was totally, so this kind of mechanism which Kamalji has chosen. Now I have found after corona and after going physically also, this is the best mechanism which saves everybody's time. हाँ, बस मिलने का जो अपना एक अंदाज और मिलना होता है, और अब तो मैं पिछले 2 सालों से चूंकि कविताएं करने लगा हूँ, तो उस बोलने में कविताओं का भी, अब चूंकि यहाँ तो उन्होंने 1 घंटे का मेरे लिए समय सीमा लक्ष्मण रेखा बांध दी, और तो अब मैं कविताएं भी, पता नहीं आप लोगों को मालूम है नहीं, आई बिकम ए पोइट ऑल्सो। अब तो मुझे कवि सम्मेलनों में भी जाना होता है एज ए कवि, तो मतलब अब तक मैंने 12 कवि सम्मेलन अटेंड किए हैं मेरे ये, लेकिन शौक मेरा अभी चढ़ा है, पिछले 2 सालों से कोरोना में टाइम मिला तो, लेकिन मैं एंजॉय करता हूँ, मैं प्रोफेशन को भी एंजॉय करता हूँ और अपनी कविताओं को भी करता हूँ। शायद आप लोगों के पास, कईयों के पास जाती भी होंगी रेगुलरली, वीकेंड पे मैं कुछ लिख देता हूँ, टेक्स्ट पे भी लिखता हूँ। तो चलो जबलपुर में आऊंगा, मेरा मन है। मैं जब सीए करता था तो 82 में मैं कटनी आया था, तो जब जबलपुर घूमने आया था, भेड़ाघाट गया था, भेड़ाघाट के वो मुझे अब तक मार्बल दोबारा जाने का मौका नहीं मिला मुझे, तो मैं जबलपुर आऊंगा कमल जी। हाँ,
We are eagerly waiting for you.
कुछ समय देके बुलाओगे तो मैं आऊंगा कमल जी,
डेफिनेटली सर।
और इस आश्वासन के साथ कि आप मुझे भी भेड़ाघाट ले जाएंगे और वो नौकायन विहार कराएंगे और वो बंदर कूदनी, वो सब चीज सिखलाएंगे।
100% आप जबलपुर को बहुत अच्छे से जानते हैं।
हाँ, मैं
एक हैंड रेज है सुरेश चंद्र जैन जी का।
अरे जैन साहब कहाँ से बोल रहे हैं? आगरा से बोल रहे हैं हमारे जैन साहब तो। हाँ जैन साहब बताइए। हाँ, अरे जैन साहब तो, हाँ
ये नमस्कार करने का बढ़िया मौका है।
अरे जैन साहब नमस्कार।
सुबह आपका मैसेज मिला तो मैंने कहा आई ऑलवेज लव टू हियर यू।
अरे सर, सो नाइस ऑफ यू, सो नाइस ऑफ यू।
रहता फ्रीक्वेंट आना जाना वाले ट्रिब्यूनल हो।
मैं आगरा परसों आ रहा हूँ मंडे को।
चलिए बहुत बढ़िया।
हाँ, नहीं मैं किसी सोशल फंक्शन में आ रहा हूँ।
हाँ, सोशल फंक्शन में, ट्रिब्यूनल तो है नहीं अभी।
हाँ, ट्राइब्यूनल तो
बेसलेस है।
जी हाँ, जी हाँ, जी। और जैसा क्या प्रश्न है?
बस प्रश्न कुछ नहीं, नमस्कार करना था।
नमस्कार।
मैंने कहा इतना बढ़िया मौका है, लाओ 2 मिनट नमस्कार।
सो नाइस ऑफ यू, सो नाइस ऑफ यू।
इसमें क्या अभी वो 48 वाले में भी क्या कर लिया? 13, 14, 14, 15 में कहीं उल्टे सीधे आ रहे डिसीजन।
देखो वो उल्टे सीधे ही है वो डिसीजन। हमने अपनी जो किताब सर्च की लिखी उस दिन, राजीव बंसल का आपका इलाहाबाद हाईकोर्ट का डिसीजन आया था। मैंने और राजकुमार जी ने, मेरे पार्टनर जो ऑथर हैं, हमने अपनी किताब में अपना मत व्यक्त कर दिया कि हम इलाहाबाद हाईकोर्ट, गुजरात हाईकोर्ट के व्यू से इत्तेफाक नहीं रखते हैं। बाकी तो कोर्ट करेगी, लेकिन एज एन ऑथर, हाँ, यदि मुझे एज एन एडवोकेट आर्ग्यू करना पड़ेगा तो मैं भी राजीव बंसल और उनको लूंगा, बट एज एन ऑथर I mean we have got some own independent। लोग प्रदीप जी बरनाला से सुन रहे हैं, और भी मैं देख रहा था संगीत गुप्ता जी हमारे हैं फरीदाबाद से, वो सुन रहे हैं।
अब आपके फैन है ना सब जगह।
अरे साहब, ये तो इसने है।
मैं भी आपके रेगुलर सुनता रहता हूँ।
हाँ, भल्ला साहब ने हाथ उठाया है। सर आप अनम्यूट करें, सर अनम्यूट करें सर। हाँ, अनम्यूट हो गए। भल्ला साहब नमस्कार।
नमस्कार सर, लुधियाना से बोल रहा हूँ मैं।
सर कहाँ से बोल रहे हैं? जबलपुर से भल्ला साहब?
लुधियाना।
अच्छा, लुधियाना। ओहो, अच्छा। हाँ, तब लोग भल्ला जी लुधियाना से बोल रहे हैं। वाह वाह वाह। देखिए साहब, अब देखिए ये संभव कहाँ हो पाता है? यदि फिजिकली हम कमल जी आपके यहाँ आते तो वो कैसे संभव हो पाता कि अब आगरा से वो भल्ला साहब, यहाँ से वो बरनाला से प्रदीप जी तो हर कार्यक्रम में होते हैं, ये इनकी खास बात है।
सर एक बात कहना चाहता हूँ। हेलो।
हाँ
सर, ऐसा है कि मैं आपके हर टॉपिक को कितनी बार सुन चुका हूँ पर मन ही नहीं भरता, और हर बार मैं फील्ड पे ही 20 बार सुन चुका हूँ पर हर बार फिर
आपने मुझे वागेश्वर धाम वाला बना दिया।
मन और तृष्णा और बढ़ रही है कि और सुने। वैसे हर बार।
भल्ला साहब आप कुछ कह रहे थे? भल्ला साहब।
सर मैं पूरी कोशिश करता हूँ आपका हर जो है ना वेबिनार ज्वाइन करूँ।
सर मैं आपका छोटा भाई हूँ सर, आप तो अपना वरद हस्त मुझ पर रखें सर। चलिए, और कोई प्रश्न नहीं है?
राकेश जी एक चीज बताइए, वैसे वही डिस्कशन में आ गया।
हाँ जैसा,
हाँ जो है, जैसे कि अगर रीजन टू बिलीव में इनकम एस्केप का अमाउंट नहीं है, उन्होंने लिखा इतने की रुपए की इन्होंने प्रॉपर्टी बेची, तो क्या ये रीजन बनता है? ये
नहीं, प्रॉपर्टी बेचना नहीं, प्रॉपर्टी केवल बेचना, फैक्ट ऑफ प्रॉपर्टी सेल इज नॉट ए ग्राउंड। और इसमें आप देखेंगे बहुत सारे डिसीजंस हैं आपके। लखनऊ बेंच ट्राइब्यूनल का ही डिसीजन है, मुझे नाम दे रहे हैं, एनके सैनी साहब ने लिखा था जब वो पोस्टेड थे। मियर फैक्टम ऑफ सेल ऑफ ए प्रॉपर्टी, ये भी तो हो सकता है मैंने प्रॉपर्टी सेल की लॉस हुआ उस पे, तो
हो सकता है।
सो देयर हैज टू बी इनकम, दैट टू चार्जेबल टू टैक्स, दैट टू मस्ट एस्केप असेसमेंट। यस,
अब वो भी अगर रिटर्न में दिखाए हुए तो वैसे भी गिना था ना।
हाँ वो तो और भी ज्यादा वो है, बिल्कुल बिल्कुल बिल्कुल।
चलिए वो क्योंकि टोटल इन एनी के सब टोटल कंसीडरेशन कभी जो है एस्केपमेंट नहीं होता। वो कहता है जी पूरा एस्केप
जी
हो गया
हाँ,
प्रॉपर्टी एक्ट से, तो मैं
जी हाँ।
मानता हूँ उसको एस्केप हो गया। मैंने कहा ऐसा कैसे हो गया यार?
ऐसा कैसे हो सकता है? लेकिन आपकी अभी नहीं चलेगी, आपकी अपील में चलेगी।
अपील में चलेगी
अभी तो उसी की चलेगी है।
ठीक बात।
ठीक है।
ठीक है, नमस्कार।
और राकेश मदान साहब तो जबलपुर से ही हैं?
यस सर, मदान सर जबलपुर के हैं।
जबलपुर से ही है, अच्छा अच्छा अच्छा।
I am born and brought up here only.
अरे वाह वाह साहब, दैट इज द सीट ऑफ हाई कोर्ट सर इन,
बिल्कुल बिल्कुल।
हाँ प्रिंसिपल सीट।
जी 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 सर।
सर मेरा एक क्वेश्चन था।
कौन का?
कमल वाली से कर।
हाँ कमल जी बोलिए।
सर मेरा एक सवाल था कि आईटीआर में क्या होता है, डेप्रिसिएशन का जो चार्ट होता है वो फिल नहीं किया था।
हाँ
तो वो उसमें डेप्रिसिएशन क्लेम नहीं हुआ आईटीआर में,
हाँ
तो उतना उसका डिमांड जनरेट हो गया। अब वो बहुत सालों तक उन्होंने क्लाइंट ने देखा ही नहीं।
हाँ
जब वो बहुत बड़ी डिमांड आ रही उनको, तब
हाँ।
उन्होंने देखा कि तो वो अपील में उसकी छूटने की संभावना होती है।
देखो ऐसा है, वैसे तो लॉ ये है, एक्सप्लेनेशन 5 जो सेक्शन 32 का है, उसमें ये दिया हुआ है कि असेसिंग ऑफिसर को डेप्रिसिएशन विच इज एडमिसिबल टू ए टैक्स पेयर विल हैव टू अलाउ। ठीक है ना? तो और सुप्रीम कोर्ट ने महिंद्रा एंड महिंद्रा मिल्स के केस में भी कहा था कि डेप्रिसिएशन देना पड़ेगा, क्योंकि पहले आपको याद हो, मदान साहब वुड वाउच, कि पहले क्या होता था कि डेप्रिसिएशन लोग जहां पर 80IA वगैरह की डिडक्शन होती थी मन से क्लेम नहीं करते थे। उनको लगता था डेप्रिसिएशन तो अब नहीं 10 साल बाद मिल जाएगा, 80IA तो अब ले लो। तो इसलिए वो एक्सप्लेनेशन 5 को इसीलिए लेके आए कि डेप्रिसिएशन तो दिया ही दिया जाएगा। तो अब इस लॉजिक के आधार पर तो डेप्रिसिएशन मिलना चाहिए, चाहे वो मुझसे रिटर्न में रह गया हो। अब उनके असेसमेंट स्क्रूटनी में नहीं हुए थे क्या?
नो सर, वो इंटीमेशन में ही सर ऐड हो गया था।
हाँ तो अब ये थोड़ा ये
बहुत सालों तक देखे नहीं किसी ने।
हाँ तो ये तो देखिए साहब, एक कहावत है कमल जी कि लॉ हेल्प्स देम हु आर विजिलेंट। ठीक है ना? if a taxpayer is sleeping over his rights, then no amount of law can come to his rescue. ये एक कहावत है।
And sir, this is for assessment year 10-11. This is very old.
तो कितने साल लगा दिए? 13 साल तो उसने उसके चैतन्य उसको चैतन्य होने में इतने वर्ष लग गए, तो अब उसकी जड़ता जो है, कितने वर्षों की जो जड़ता है, अब उस पर ये टैक्स मरता है। तो अब
चलिए, मेरा भी एक क्वेरी है कमल जी।
हाँ सर बताइए, मदान साहब बताइए सर।
मेरा तो अभी जो रिसेंट चल रहा है उससे रिलेटेड एक क्वेरी थी कि
हाँ बताइए सर।
पॉलिटिकल वाला जो है, पॉलिटिकल कंट्रीब्यूशन वाला है, ये केस चल रहा है ऑल ओवर इंडिया में।
जी जी जी,
मस्ट हैव आल्सो सीन।
हाँ जी हाँ जी हाँ जी हाँ जी हाँ जी।
तो उसमें एक मेरे क्लाइंट को उन्होंने नोटिस दिया, गिविंग एन अपॉर्चुनिटी कि व्हाई 148 शुड नॉट बी ओपन।
हाँ
तो 148 का उन्होंने आजकल वो जो अपॉर्चुनिटी देनी रहती तो अपॉर्चुनिटी दी।
आई वॉश जो है वो, हाँ
आई वॉश, दिस इज द राइट वर्ड यू हैव यूज्ड।
हाँ।
तो उसका अच्छा रिप्लाई बना के दिया पूरा डिटेल में, that 148 should not be issued. तो वो उनका तो फट से ऑर्डर भी आ गया और बोले कि इस टाइम तक दिया हुआ था and they have not replied anything. तो उन्हें रिप्लाई नहीं देखा है और बोलते हैं कि रिप्लाइड एनीथिंग।
सर बात ये है ना,
रेडीमेड ऑर्डर था, लगता है मुझे रेडीमेड ऑर्डर भेज दिया।
बात ये है कि इस तरह के क्लाइंट्स के साथ जो सोसाइटी का परसेप्शन है ना, वो बड़ा गलत है। तो इसलिए उनको जो नॉर्मल रिलीफ भी जो मिलना होता है, वो उससे भी वो महरूम रह जाते हैं
जी।
लेकिन फिर भी अब यदि उसने बिल्कुल आपका रिप्लाई देखा ही नहीं
जी।
तो अब आप ज्यादा से ज्यादा क्या रिट में जाकर हाई कोर्ट भी कहेगा भाई जाके देख लो, वो देख के भी क्या हो जाना है, यही होना है।
यस, अभी वो रिसेंटली दिल्ली हाई कोर्ट का केस हुआ है ना, उसमें भी क्या बोला उन्होंने दे दिया कि भैया इसको देखो।
यस, आपको ध्यान हो फाइनेंस एक्ट 2022 से पहले 2021 में ही प्रोविजन लाए थे 144B में कि यदि इस तरह की चीज हो गई है तो पूरा असेसमेंट ही बैड हो जाएगा, चाहे वो ड्राफ्ट असेसमेंट ऑर्डर नहीं हो या वेरिएशन का शो कॉज ना दिया गया हो। इन्होंने फिर 2022 में अमेंडमेंट लाए 144B में कि यार वो नलिटी नहीं होगा, वो एक इर्रेगुलरिटी होगा। तो इसलिए नेचुरल जस्टिस की नॉन ऑब्जर्वेंस को तो ये इलीगलिटी नहीं, इर्रेगुलरिटी मानते हैं।
तो फिर अब रेट पे अगर नहीं जाएंगे, रेट की क्योंकि एडिशनल कॉस्ट है, फिर वापस यहीं आना है।
नहीं तो कोई फायदा नहीं है, आप अपील में लड़िएगा सर इसे।
हाँ, तो अभी तो बस जो 148 होएगा वो प्रोसीडिंग करने दें।
जी हाँ।
और वो जो रिप्लाई दिया हुआ है वो अपील में काम
वो काम आएगा, काम आएगा सर, काम आएगा। हाँ, ठीक है सर।
So this would be the right course of action.
Yes sir.
Thank you sir.
हाँ जी कमल जी।
यस सर।
हाँ बताओ सर।
बस सर मेरे ख्याल से अब तो की क्वेरी नहीं है सर।
हाँ। अब गुरमीत जी हमारे दिल्ली से हैं, चलिएगा साहब।
सर लखनऊ से।
अच्छा, गुरमीत जी लखनऊ वाले हैं, दिल्ली वाले नहीं हैं। अच्छा
सर जी सर, और कैसे सर? सब ठीक?
बहुत अच्छा। हाँ गुरमीत भाई ठीक है सर।
जी, कविताएं आपके पढ़ते रहते हैं सर।
अरे सर
जी, थैंक यू सर।
तो अब खत्म कर दो कमल जी, हमारी पत्नी इंतजार कर रही हैं।
बस सर, मैं पहले तो आपसे बीच में जो परेशानी हुई उसके लिए माफी चाहता हूँ।
नहीं कोई नहीं, ये चलता है। हाँ, ये डेमोक्रेसी हमारे यहाँ
सर। बस, और आपका प्रॉपर इंट्रोडक्शन भी नहीं कर पाए, लाइट बंद हुई तो सभी को ऐसे मोबाइल पे भेज दिया था आपको इंट्रोडक्शन सभी को।
ये मुजफ्फर अली अंसारी साहब कहाँ से हैं? आपके जबलपुर से हैं क्या?
नहीं, यहाँ के तो
नहीं, यहाँ पे नहीं है।
यहाँ के नहीं। अच्छा,
सहारनपुर से।
अच्छा सहारनपुर से है मुजफ्फर साहब। ओके।
पूरा यूपी दिल्ली पूरा कवर कर दिया आपने, पंजाब।
हाँ पंजाब यूपी सर, हमारे 25 जरूर थे लेकिन 1.25 लाख से एक लड़ाऊ थे सारे।
बिल्कुल। थैंक यू सर। मैं आपको सर आज की इस वेबिनार के लिए बहुत बहुत धन्यवाद देता हूँ सर, कि आपने हमारी छोटी ब्रांच को इतना मान दिया कि हमारी रिक्वेस्ट को एक्सेप्ट किया सर आपने। नॉर्मली मैं आपके दिल्ली की सुनता रहता हूँ वेबिनार जो भी होते हैं। थैंक यू सर। और भविष्य में बहुत जल्द मैं आपको जबलपुर इनवाइट करूंगा और आप
आइए। जरूर। और बिलैया साहब ने भी कहा है कि आप जबलपुर होके आइए राकेश जी, ये कोई मतलब नहीं होता। बोले कमल को मैं बोलता हूँ। मैंने कहा नहीं, कमल जी का ही फोन आया है हमारे पास। ओके जी, नमस्कार जी, नमस्कार।
थैंक्स
नमस्कार सर, नमस्कार।
थैंक्स टू ऑल।
सभी को नमस्कार।